What are you doing right up on my car?
Just offering to clean the windshield, sir. $2.
You got ID on you?
Not on me. I'm a U.S. citizen. Just don't carry it when I'm working.
I don't know that. Anybody can say that.
I'm not trying to cause trouble.
Name doesn't help me if you're lying. Where's your ID?
I don't have it. I'm not refused. I just don't have it.
I don't believe you. Step back from the vehicle now.
Based on the findings, the board has determined that Officer Daniel Mercer violated departmental policy regarding discretionary enforcement escalation. Effective immediately, you are relieved of duty pending termination review.
Please step outside. Thank you.
On a warm Tuesday afternoon in Phoenix, Arizona, traffic thickened near the intersection of West Van Buren Street and North 19th Avenue. The light stayed red longer than usual. Engines idled. Drivers waited, detached, impatient. That was when Calvin Brooks stepped off the curb. Calvin was a black man in his early 60s, tall but lean, his posture slightly bent forward as if his body remembered years of physical labor. He wore a sun-faded gray windbreaker, dark jeans, and worn sneakers. In his right hand, he carried a small plastic bucket. Inside it, a squeegee, a spray bottle, and a folded rag. His movements were slow but deliberate. Confident, familiar, he approached the first car, stopping a few feet away. A driver shook his head. Calvin nodded back and moved on. At the next car, a woman cracked her window, handed him $1. Calvin cleaned the glass in one smooth motion and stepped back as the light turned green. When the cars stopped again, Calvin found himself facing a marked Phoenix Police Department cruiser. The vehicle sat in the left lane, engine running, windows tinted. The officer inside looked straight ahead, unmoving. Calvin paused. He had learned over time to read situations. Some cars welcomed him, others didn't. Police cars were unpredictable. Still, the light was red and the cruiser was no different from the others. Calvin raised the squeegee slightly and pointed toward the windshield, a silent, practiced offer. The officer turned his head. After a brief pause, the window rolled down halfway. "What are you doing?" the officer asked. Calvin kept his hands visible. "Just offering to clean windshields, sir, $2. The officer's eyes moved from Calvin's face to the bucket, then back again. "You got identification on you?" Calvin frowned slightly. "No, sir, I don't carry it while I'm working." The officer's expression hardened. "You're supposed to have ID," he said. "For cleaning windows?" Calvin asked. His tone was calm, genuinely puzzled. The officer shifted in his seat. "Step away from the vehicle." Calvin complied immediately, backing up with both hands raised slightly away from his sides. Behind the cruiser, a driver leaned on the horn. The traffic light turned green, but the police car didn't move. "What did I do wrong?" Calvin asked. "You're soliciting in traffic," the officer replied. "That's an offense." "I only ask," Calvin said. "If they say no, I walk away." The officer opened the door. Traffic stopped again. A few drivers lifted their phones. Someone on the sidewalk slowed to watch. "Turn around," the officer said. "Hands behind your back." Calvin froze for a moment. "Sir, I'm not resisting, I just don't understand." "Turn around," the officer repeated. Calvin did as he was told. As the handcuffs clicked shut around his wrists, the bucket tipped over. Water spilled across the asphalt. The squeegee slid toward the curb. A second patrol unit pulled in behind them. Calvin didn't raise his voice. He didn't struggle. As he was guided toward the back seat of the cruiser, he asked a single question twice. "What law did I break?" The officer didn't answer. A man from the sidewalk shouted. He wasn't bothering anyone. The cruiser door closed. The light turned green once more. Cars moved on as if nothing had happened. What no one at that intersection knew, including the officer, was that this stop would not be resolved by the end of the shift. It would become a case. And it would raise a question far bigger than whether a man had ID in his pocket. It would force investigators to ask why Calvin Brooks was stopped at all. By the end of the day, the arrest of Calvin Brooks had already been reduced to a paragraph in an internal police report. According to that report, the incident was routine. Officer Daniel H. Mercer, a 6-year veteran of the Phoenix Police Department, documented that he observed an individual actively soliciting services in an active roadway, creating what he described as a potential traffic hazard. The individual, later identified as Calvin Brooks, was said to have approached multiple vehicles during a red light cycle. When Officer Mercer made contact, the report stated Brooks was unable to provide government-issued identification upon request. That detail mattered. Under departmental policy, officers were authorized to detain individuals suspected of committing a misdemeanor offense when identity could not be reasonably verified at the scene. Mercer wrote that Brooks was uncooperative in clarifying his identity and that verbal commands were required multiple times before compliance was achieved. The report made no mention of raised voices. no mention of confusion. No mention of bystanders, just procedure. Brooks was booked at the Maricopa County Jail on a charge of obstructing a public roadway and failure to identify during a lawful stop. His personal property, including the plastic bucket, squeegee, and $14 in cash, was logged and stored. At 7:42 p.m., Calvin Brooks was released on his own recognizance. No press release was issued. From the department's perspective, the case was closed. But outside the paperwork, the story didn't sit as cleanly. The first issue came from dispatch logs. Records showed that no traffic control complaints had been made at that intersection that afternoon. No accidents, no near misses, no calls from motorists about aggressive solicitation. The second issue came from witnesses. Within hours of the arrest, 2 short cell phone videos began circulating locally. Neither showed the full interaction. One clip started just as Calvin was being turned toward the cruiser. The other captured the spilled bucket and a bystander shouting that he didn't do anything wrong. Neither video showed Calvin acting aggressively. Neither video showed him blocking traffic. Still, the department stood by the report. When asked informally by a supervising sergeant why the arrest escalated, Mercer reportedly replied that the situation felt off and that Brooks matched behaviors commonly associated with transient solicitation. That phrasing raised no immediate alarms. It was vague, subjective, and entirely defensible on paper. But there was a third issue, one that didn't surface until the following morning. During intake processing, Brooks had calmly informed a detention officer that he was a U.S. citizen and a military veteran. The officer noted it but did not flag it. There was no legal requirement to do so. However, when Brooks later contacted a local legal aid office for assistance with his citation, the intake attorney asked a routine question. "Have you ever been arrested before?" Brooks answered no. Then he added something else. He said he had been washing car windows at intersections for nearly 10 years. He said police had warned him before, told him to move along, but no one had ever arrested him. And then he said quietly, "The officer never told me I was under investigation. He just asked for my ID." That statement contradicted the report. According to Mercer's account, Brooks had been detained due to an observed offense before identification was requested. According to Brooks, the request for ID came first. It was a small difference. But in cases like this, small differences mattered. Because if the request for identification came before reasonable suspicion was established, the entire stop changed character. At that point, it was no longer about traffic safety. It was about discretion. And discretion, investigators knew, was where bias often hid, not in what was done, but in why it was done to one person and not another. By the end of the week, a request was quietly submitted to review Officer Mercer's body camera footage. Not because anyone expected wrongdoing, but because the official version, while clean, left too many unanswered questions. And the footage, once reviewed, would complicate everything. The body camera footage was reviewed 3 days after the arrest, not because of public pressure, not because of media attention, but because a junior lieutenant in the department noticed something subtle in the paperwork. The timeline didn't align. According to Officer Daniel Mercer's report, Calvin Brooks had been observed committing a traffic-related offense before any request for identification was made. That sequence justified the stop. It justified the detention, and ultimately it justified the arrest. The body camera told a different story. The footage opened with ambient street noise, engines, horns, the hum of traffic waiting at a red light. The camera angle showed the inside of the patrol car, then shifted slightly as Mercer turned his head. Calvin Brooks appeared at the edge of the frame. He wasn't standing in front of the vehicle. He wasn't blocking the lane. He was several feet off to the side, closer to the curb than the bumper. The first audible words came from the officer. "What are you doing here?" There was no mention of an offense, no warning, no instruction to move away from traffic. Calvin answered calmly, exactly as he later claimed he had, "Offering to clean the windshield, sir, $2. The next question came immediately. "You got ID on you?" There was no pause, no explanation. No statement of suspicion, just the question. When Calvin said he didn't have identification with him, Mercer's tone changed. His voice became sharper, more controlled. "You're not supposed to be out here doing that." Still, no law was cited. The review panel watched carefully as the interaction unfolded frame by frame. Calvin stepped back when told to. His hands were visible. His responses were slow, deliberate, non-confrontational. At no point did he raise his voice. At no point did Mercer explain that Calvin was being detained or investigated for a specific offense. The order to turn around and place his hands behind his back came less than 30 seconds after the initial contact. That detail mattered. Under departmental guidelines, an officer must be able to articulate reasonable suspicion before escalating a voluntary encounter into a detention. The footage showed the escalation first and the justification later. When Mercer stated on camera, "You're soliciting in traffic," it came after Calvin had already been physically repositioned near the cruiser. The sequence was backwards. Even more concerning was what didn't happen. Mercer never asked Calvin to leave the intersection, never issued a warning, never attempted de-escalation. The arrest was the first and only tool used. By the end of the footage, Calvin could be heard asking a question that never appeared in the official report. "What law did I break?" There was no response. The room stayed quiet when the video ended. No one accused Mercer of misconduct. Not yet, but the tone shifted. This was no longer a routine arrest review. It was now a question of whether the officer's stated reasoning had been constructed after the fact to justify a decision already made. A second review followed. This time, investigators compared the footage to prior bodycam recordings from the same intersection. Over the previous 18 months, at least 7 similar interactions were found. Individuals washing windows or asking for money. In every other instance, the encounter ended with a warning. No ID request, no detention, no arrest. The difference was not the behavior, it was the person. That realization didn't lead to immediate action. Institutions rarely move quickly against their own. Instead, the case was quietly reclassified. What began as a minor arrest review was now logged as a potential bias-related stop. And once that label was applied, the scope of the investigation expanded automatically. Personnel records, training history, prior complaints. Officer Mercer's past interactions were about to be examined under a microscope. And the deeper investigators looked, the harder it became to argue that this arrest had been unavoidable. Because the footage showed something simple and unsettling. Calvin Brooks hadn't been stopped for what he did. He had been stopped because the officer decided within seconds that he didn't belong there. Once the incident involving Calvin Brooks was formally reclassified as a potential bias-related stop, the tone inside the Phoenix Police Department shifted. Quietly at first, the case was transferred from a routine supervisory review to the Professional Standards Bureau. That move alone changed everything. What had once been a closed file was now subject to subpoena, internal interviews, and mandatory documentation. Officer Daniel Mercer was notified on a Thursday morning. The notification was brief, administrative. It informed him that his body camera footage and written report were under extended review and that he was required to submit a supplemental statement clarifying the basis for reasonable suspicion prior to requesting identification. Mercer complied within hours. In his supplemental statement, he doubled down. He wrote that Brooks's presence in the roadway created an unsafe condition and that his experience told him such situations could escalate unpredictably. He added that Brooks appeared evasive when asked about identification and that his refusal raised concerns about outstanding warrants. There was a problem with that explanation. The bodycam footage did not support it. Investigators noted that Brooks never refused to identify himself. He stated clearly that he did not have physical ID on him. He answered every question asked. He complied with every instruction given. More importantly, Mercer's report still failed to articulate why Brooks was singled out when similar conduct at the same intersection had previously resulted in warnings, not arrests. That inconsistency triggered the next step. Internal Affairs requested Mercer's enforcement history. The data showed a pattern that was not illegal on its face but uncomfortable in context. Over the previous 3 years, Mercer had made a disproportionately high number of pedestrian stops involving black men over the age of 50. Most resulted in warnings. A few resulted in citations. Only one resulted in an arrest, Calvin Brooks. Still, the department resisted escalation. Supervisors cautioned investigators against overinterpreting data. The union representative assigned to Mercer argued that enforcement discretion varied by circumstance and that no 2 encounters were the same. Technically, they were correct. But the pressure continued to build. When Brooks failed to appear for his initial court date, not out of defiance but confusion, a bench warrant was briefly issued before being withdrawn. That administrative error placed Brooks in further legal jeopardy and forced him to seek formal representation. That was the moment the case left the building. A civil rights attorney filed a notice of claim against the city, alleging unlawful detention, arrest without probable cause, and racial bias. The filing referenced body camera footage, witness statements, and departmental data. Once that notice was received, the city was required to preserve all related records, emails, training logs, prior complaints. The department placed Officer Mercer on paid administrative leave. Publicly, the department framed the move as neutral. Privately, it was a signal. By now, local media had begun asking questions, not aggressively but persistently. Why was a 60-year-old man arrested for window washing? Why was no citation issued instead? Why did the report and the video not align? Mercer was instructed not to discuss the case. Brooks, meanwhile, sat quietly at home, dealing with something the reports didn't capture. For the first time in years, he stopped going to the intersection. He told his attorney he no longer felt safe standing near traffic with a bucket in his hand. He worried that any interaction could escalate again, and next time he might not be released the same day. As the investigation widened, one thing became clear. This was no longer about a single stop. It was about whether the department could convincingly argue that race played no role despite evidence suggesting otherwise. And with each document reviewed, that argument became harder to sustain. Because the case had reached a point of no return, and the next phase would force someone, either the city or the officer, to accept responsibility. The breakthrough did not come from the body camera. It came from a document that almost no one expected to matter. As part of the civil claim, the city's legal department requested Calvin Brooks's background records, not to discredit him, but to assess potential damages. Employment history, medical records, prior arrests. What they found changed the posture of the entire case. Calvin Brooks was not transient, he was not unemployed, and he was not unknown to the federal government. In 1984, Brooks had enlisted in the United States Army. He served 8 years, including 2 overseas deployments during the Gulf War era. His discharge status was honorable. His service record showed no disciplinary actions. More importantly, his name appeared in a Department of Veterans Affairs registry tied to long-term service-related injuries. Brooks had been receiving limited VA benefits for more than 2 decades. That information had never been disclosed during the arrest because no one had asked. When Internal Affairs reviewed the intake footage from the jail, they noticed something else. During processing, Brooks calmly answered a routine question about military service. The detention officer acknowledged it and moved on. The information was entered into the system, but it was never relayed to the arresting officer. Legally, it didn't have to be, but procedurally it mattered. Once Brooks's veteran status became known, the optics shifted dramatically. A 60-year-old U.S. Army veteran, arrested, handcuffed, and placed in a squad car for offering to wash windshields. That was no longer a gray area policy dispute. That was a narrative problem the city could not ignore. The situation escalated further when Brooks's attorney requested Mercer's full training history. Among the records was a mandatory bias awareness course completed 2 years earlier. Mercer had failed the initial assessment. He passed on the second attempt. That alone was not misconduct. But when paired with his enforcement history, the pattern became harder to dismiss. Then came the email. Buried in a routine internal exchange from the year before, Mercer had written to a colleague after a pedestrian stop. The message was informal, frustrated. "These guys hang around intersections all day, you give them an inch and they take over." The email did not mention race, but investigators didn't need it to. Because the stops associated with Mercer told their own story. Older black men, public spaces, low-level discretion calls, always escalated faster than policy suggested. When the findings were presented to command staff, the room reportedly went silent. This was no longer about whether Mercer followed the letter of the law. It was about whether his decisions consistently pushed certain people closer to arrest, while others walked away with warnings. At the same time, Brooks underwent an independent psychological evaluation as part of the civil process. The report documented heightened anxiety following the arrest, particularly related to law enforcement encounters. The evaluation cited his military background. Brooks had spent years being trained to comply with authority under stress. Being treated as a suspect without explanation had triggered symptoms he had not experienced in decades. That report was admissible. By now, the city faced 2 paths: proceed to trial and risk a jury seeing the footage, the data, the emails, and the veteran's record, or resolve the matter quietly. Officer Mercer remained on administrative leave. No charges were filed against him, not yet, but the question had shifted. It was no longer whether the arrest was legal. It was whether the city was prepared to defend it. And that decision would be made very soon. By the time the case reached formal mediation, both sides understood what was at stake. For the city, it was no longer just about Calvin Brooks. A public trial would put the department's discretionary practices under scrutiny. Patterns would be questioned, policies dissected, decisions compared. For Officer Daniel Mercer, it was more personal. If the case went to court, his body camera footage would be played frame by frame. His emails would be read aloud. His enforcement history would be projected onto a screen and analyzed by people with no loyalty to the badge. And none of it would be contextualized the way police departments usually did internally. The mediation was scheduled for a Friday morning. In a conference room downtown, city attorneys sat across from Brooks's legal team. No cameras, no reporters, just binders, transcripts, and timelines. The city's position was straightforward. They argued that Mercer had legal authority to engage Brooks, that the request for identification was lawful, and that the arrest, while unfortunate, fell within acceptable bounds of officer discretion. They emphasized that Brooks was released the same day and suffered no physical injury. Brooks's attorney didn't raise his voice. Instead, he walked through the bodycam footage again, second by second. He paused at the moment the ID request was made. Then at the moment Calvin stepped back, hands visible. Then at the point where Mercer escalated the encounter without warning. This, he said, tapping the table lightly, is where discretion becomes discrimination. The city countered with policy language. The attorney countered with comparison footage, 7 prior encounters at the same intersection. Same behavior. Different outcomes, warnings instead of arrests. He didn't say race, he didn't have to, then he introduced the final element. Impact. Calvin Brooks had not returned to that intersection since the arrest. His income had dropped. His anxiety had increased. He avoided police vehicles. He avoided crowds. A 60-year-old veteran trained to trust command structure now flinched at sirens. The city's attorneys took notes. They asked for time. Behind closed doors, the discussion shifted. Risk assessment replaced legal theory. A jury, they knew, would not see a policy debate. They would see a man in handcuffs, a bucket on the ground, a question that went unanswered. What law did I break? And they would hear that he was a veteran. They would hear that he was never warned. They would hear that others were. Meanwhile, Officer Mercer was informed that the department's disciplinary board would not wait for the civil case to conclude. A parallel administrative review was scheduled. The possible outcomes were outlined plainly: written reprimand, suspension, or termination. Mercer declined to testify in the civil mediation. On advice of counsel, he submitted a final written statement reiterating his belief that the stop was justified. That statement would become part of the record. By late afternoon, the city requested a second mediation session. This time they came prepared to talk numbers, not because they believed they would lose, but because the cost of defending the case financially and reputationally was climbing fast. Outside the room, Calvin Brooks sat quietly beside his attorney. He said very little. When asked what he wanted, his answer was simple: "I don't want this to happen to anyone else." The mediation adjourned without agreement. But the tone had changed. The city was no longer asking if they could fight the case. They were asking whether they should, and with the disciplinary board date approaching, the window to decide was closing fast. The case never went to trial. 3 days before the disciplinary board was scheduled to convene, the city of Phoenix made its decision. A settlement agreement was drafted, reviewed, and finalized without public announcement. There was no press conference, no admission of wrongdoing, just a quiet resolution approved behind closed doors by the city council's legal committee. Calvin Brooks was awarded $675,000. The settlement cited unlawful detention, improper escalation of a voluntary encounter, and failure to follow departmental procedures regarding discretionary enforcement. The language was careful, neutral, legal. But the message was clear. The city did not want a jury to see the footage. As part of the agreement, Brooks did not waive his right to speak about what happened. He was not required to sign a non-disclosure clause. That omission was intentional and unusual. Internally, the department moved faster. The disciplinary board reviewed Officer Daniel Mercer's case using a lower burden of proof than a civil court. The focus was not on criminal intent, but on conduct. The findings were unanimous. Mercer had escalated the encounter without articulable reasonable suspicion. He had requested identification during a voluntary contact without legal necessity. And he had failed to apply the same discretion shown in comparable situations involving other individuals. Bias was never written explicitly into the final determination. Instead, the board used the phrase "demonstrated pattern of inconsistent enforcement." Mercer was indefinitely suspended without pay, pending termination review. 2 weeks later, he resigned. The department released a short statement confirming his departure and reiterating its commitment to fair and impartial policing. No further details were provided. Calvin Brooks received his compensation check on a Monday morning. He deposited it quietly. No interviews, no speeches. When asked by his attorney what he planned to do next, Brooks said he intended to pay off his debts, move closer to family, and stop working intersections altogether. He never returned to West Van Buren Street. In the months that followed, the department updated its training protocols on pedestrian encounters and ID requests. Officers were reminded, in writing, that voluntary interactions could not be transformed into detentions without clear justification. The memo did not mention Brooks by name, but everyone knew why it existed. This case did not end with handcuffs reversed or an apology issued on camera. It ended the way many real cases do, with paperwork, with money, with a career quietly ending. And with a man who did nothing illegal learning, at 60 years old, how quickly a routine moment could spiral when discretion went unchecked. Because the arrest was never really about identification. It was about who the officer believed belonged there. If you made it this far, subscribe and like the video. These cases matter, and they don't get told this way by accident. Now the real question. Backhand index pointing right. If you were in Calvin Brooks's place, would you have handed over your ID or asked the officer to explain his authority first?